A South Australian man has mounted a legal challenge against compulsory voting at state and federal elections. If he wins, the result could have implications for the entire voting system nationwide.
Anders Holmdahl has lived and voted in a number of countries in his 65 years, but chose not to vote at the federal election in August 2010. He was found guilty by a magistrate of failing to vote at an election, and rather than accept the $20 fine, he's challenging his conviction in South Australia's Supreme Court.
I don't really understand what is the difference by going to a polling booth, putting a blank vote or what I call a donkey vote in, or not going. The only difference is that you get fined and prosecuted if you don't put your name in a polling booth.
Filming was permitted in the special sitting of the Supreme Court at Flinders University in honour of the law school's 25th anniversary. During the hearing, Mr Holmdahl's lawyer Kevin Borick said that under the Constitution, people have a right to vote. He argued the Constitution overrules the Commonwealth Electoral Act, which says people have a duty to vote.
We say that it's a right and not a duty, and if it's a right, well, then you can't compel a person to do it, to vote. If it's a duty, well, you can.
Michelle Barnes for the Electoral Commission said the Supreme Court was bound by previous High Court rulings on the issue, which upheld compulsory voting. Justice Tom Gray reserved his judgment. Mr Holmdahl has conceded the matter is probably destined for the High Court regardless of Justice Gray's decision, because whichever party loses is likely to appeal. Lucas Fontaine, ABC News, Adelaide.